Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh their attention to the court now sitting.
Thank you. Please be seated. Good morning and welcome to the Supreme Court of Kansas. A special welcome to some visitors I see in our gallery. I understand they are from the Grow Your Own Lawyer program from Wichita. Is that correct? Yes, sir. Is there a spokesperson who'd like to make a speech?
I'll do it.
You'd stick to the lectern here and speak right up. All right.
Right there?
Right there.
Hello, I am a representative from East High, and this is our lovely bunch, well, a portion of it, because a lot of them probably didn't want to wake up really early. But we left town around 7 o'clock, and now we are here, and we are super excited to sit in the gallery and watch this happen. So, yes. It's nice seeing all of you guys, and I really like your mustache. It reminds me of Teddy Roosevelt. Have you gotten that before?
Reminds you of who?
Teddy Roosevelt.
Oh, you're supposed to say Tom Selleck.
I'm sorry.
That's quite all right.
Okay, well, hi.
Thank you very much.
Your name,
Glad to have you.
please. Your name, please.
I'm Antonia Carson.
Very nice presentation.
As far as you realize that the proceedings this morning are being broadcast live over the internet. And later today, because these are archived, you'll be able to go to your computer and see how you did. Very good. All right. Ms. Green, back to serious business. I now call the first case on this morning's docket. That is case number 104827, State of Kansas v. Samuel D. Llamas.
May it please the Court, Rachel Pickering of the Appellate Defender Office on behalf of Samuel Llamas, if this Court please reserve 2 minutes rebuttal time.
2 minutes?
2 minutes. Chief Justice, 2 minutes. Before I begin, I must tell this Court that I'm arguing this case for Ryan Enninger. He's one of the 2 attorneys who has left our office. I don't know what happened to the other attorney, but we will wish Mr. Enninger well in his new endeavors. I will be arguing the first issue today, which is the judge's decision not to grant the defendant's motion for acquittal after the state presented its evidence. And basically, we could describe the events of this shooting without even discussing Mr. Llamas's involvement. That's how much of an issue we think we have here in terms of he was not aiding or abetting. We have a crime that, as the state says, goes all the way back to July of 2009. There's a drug transaction. And I'm going back to the facts to show this Court that's how far back the state has to reach to bring Mr. Llamas's involvement in. We have a transaction between Mr. Mike Navarro and Mr. Flores. Mr. Navarro goes to California to get $2,000 worth of meth. He comes back on a train in Kansas City. Mr. Flores is there. They meet, and Mr. Flores is supposed to sell $2,000 worth of meth, give the $2,000 back to Mr. Navarro. He never pays him. And that happens in the months of July and August. We have no payment at all. Sometime in August, Mr. Navarro runs into Mr. Flores asking for that money. It's called the Burrito Shack incident, where Mr. Flores leaves his car and he and Mr. Flores and Mr. Navarro. Mr. Flores is going to be the victim in the shooting, and Mr. Navarro have a private conversation. And the discussion is that Mr. Navarro will receive his money within about a week from Mr. Flores. That doesn't happen. Sometime around that same time, we have a phone call to apparently the money supplier, Mike Miller, and from a guy named Joe, but it's really supposed to be Mr. Navarro, having someone pose as a California guy, saying, "Mr. Flores better pay now, or something will happen." So
pretty much undisputed that California guy stand-in is the defendant, Mr. Llamas?
it is disputed.
It is disputed.
It is disputed because we're not sure. When Ruby, the girlfriend of Mr. Navarro, hears the conversation, she's not sure if it is exactly the call to Mr. Miller. There's some question there. We also have Mr. Miller not being able to identify whose voice he heard when he received the call. But even if you do have that call, that is weeks before the shooting. And that's critical here. We have all these events going from July, and now we have a shooting that takes place September 8th.
Why is the motel owner Patel's statement to police about the two men being outside of the Honda, one standing by the driver's door of the Suburban and getting into the passenger door of the Honda, and the other man standing by the Honda and getting in the driver's door and driving away, not enough to implicate Mr. Llamas as an aider and abettor in the shooting?
I think, if anything, that would be the one piece that the state could possibly argue that, and we're inferring here that Mr. Llamas was the one who was standing by the car, inferring that it was Mr. Llamas who got in the driver's side. It was very dark that evening. Mr. Patel's statement at trial completely contradicts that. His statement to the detective, he's very unclear about actually what he heard. It's inconsistent. We have firecrackers popping versus gunshots. We have no testimony by Mr. Patel of who he, being able to identify who these two men look like, that the person who supposedly gets in the driver's side is Mr. Llamas. He's never able to identify Mr. Llamas at trial. So we would argue that is that one fact. That's probably the best the state has.
And why is that not enough under the standard of review that we apply to this issue?
Because there is, because we're not sure, I already argued that there's more facts showing that Mr. Even in the light most favorable, you can't even show that he was actually the driver. I think that's the point of, well, you have circumstantial evidence, but how much of an inference can you show from that? Reliance is placed on circumstantial evidence. The circumstances question must themselves be proved and cannot be inferred or presumed from other circumstances. And so our point is you can't infer a lot from that one statement. And that should be, I'm saying that's the best they have, but that still isn't sufficient because we're not sure that Mr. Llamas was actually the driver.
And if not, then he was the man standing at the door of the Suburban where the shots were
Well,
fired.
you're not sure. You got to remember, Mr. Patel, it was very, very dark. In his trial testimony, he gets completely conflicting testimony.
Except doesn't your client admit to being there? He just says he stayed in the car.
Yes, but even if
And nobody else puts anybody else in the Honda? There are only the two of them, Navarro
Correct.
and Llamas, yeah.
Right.
So that's pretty strong circumstantial evidence that he was either if there were two men who were in the Honda, one at the driver's door of the Honda and the other at the driver's door of the Suburban, that he was one or the other. Isn't that pretty strong circumstantial
Yes, but
evidence?
we're not sure. I still think from Mr. Patel's testimony, there's a lot of uncertainty as to where these men were. That's my point. He may have given that to the detective, but his trial testimony conflicts with that. And
But that's precisely what the jury's for.
right.
Make those
And I'm not here to quibble about that. Although I think I just did. But I am. But we would argue that shouldn't be enough here. The fact that he may have been in the driver's side. We do have them appearing at the gas station later, but you don't have you don't see Mr. Llamas with keys in his hand.
Well, can
Being
I
the driver.
take you back to your impermissible stacking of inferences? If the inference of participation rather than mere presence comes from the eyewitness testimony of where the defendant or where the two people are. What is the inference from which you're drawing the other inference? The testimony that this person was seen to be right here is direct testimony. That's not an inference, is it?
No, he's seen by the passenger car, but I don't know if there was testimony.
And from that direct testimony, you draw the inference that he wasn't sitting in the car, as he said, but he was participating. So how is that stacking of inferences?
I would argue standing outside a car is not participating because the shooting takes place away from that car, closer to where the Suburban is. So standing outside a car in the evening at 7 o'clock, he said he was looking at some girls. I would say that is not enough to be participating. Because remember, we have him, Mr. Llamas, when Mr. And certainly I would hate for me, if I want to stretch my legs, to be able to be standing outside a car, and if a shooting takes place, I shouldn't be held responsible for that. How am I aiding and abetting by being present? Mr. Llamas is not a figure that is threatening. He drinks a lot. One of the witnesses said that he makes a very bad job of being the muscle because he's not really he doesn't give him threatening words. There's no testimony that he himself has carried handguns. So we would argue that him being present simply isn't enough. What's important here, and what I wanted to discuss just for a moment before I ask this court to reverse and remand, is the fact of the state's closing. The state's closing says, and this is how we're arguing mere presence, the state's closing discusses he's complicit. He didn't actively get up there and help him shoot the gun. He doesn't do a thing to step in and end it. He's complicit. We would argue that that's simply not enough. Standing outside the car is not enough. Here's how poor the evidence is, we would argue. The state says, however or whatever form it took, Mr. Llamas was an active participant. So is that form standing outside a car? Is that aiding? So however, whatever, that's how vague the state's case is against Mr. Llamas's. But the one thing I wanted to end with is that we have a double specific intent here. For aiding and abetting, he has to be convicted of a specific intent crime. The defendant must have the same specific intent crime to commit the crime as the principal. And here we had an idea that maybe Mr. Flores was going to get jumped, maybe he was going to get messed up, but we couldn't argue that the same specific intent to have criminal discharge of a firearm. And so you have specific intent that you need for aiding and abetting, and you have specific intent for criminal discharge of a firearm. If there's no further questions.
Any further questions of counsel? Thank you, counsel.
Thank you.
Good morning. May it please the court. I'm Sarah Washburn. I'm Assistant Lyon County Attorney, and I'm here for the state appellee, and I'm ready to stand on my brief and take any questions if you have any.
What was the act, or what did defendant do to aid and abet the criminal discharge of the firearm at an occupied vehicle?
Well, Your Honor, I think that Justice Beyer is absolutely, no, I'm sorry, it was Justice Rosen, I think, who was asking the questions, made a very good point about the fact that there is eyewitness testimony, and I believe you pointed this out as well, that Mr. Patel, who was the owner of the motel, did in fact observe two men outside of the vehicle. One who was actually the individual who fired into the vehicle, the other who was, after the firing, got into the driver's side of the vehicle and drove the vehicle away. And
why isn't driving the vehicle away from the scene aiding a felon after the fact rather than aiding and abetting the criminal act?
I believe it's a question of how close in time we're talking about. I think it was a question of Mr. Navarro firing into the vehicle. They immediately jump into the car, and he facilitated the crime of firing into the vehicle by ensuring a very speedy escape.
Well, but that aided and abetted with the getaway. How did that aid and abet the firing of the firearm, discharge of the firearm at the occupied vehicle?
Well, Mr. Flores, according to the medical examiner, was seated in the driver's side and ended up slumped over the passenger console. And if you have one individual standing outside of the car with a weapon and you have another individual standing there, I think there's an argument at least that can be made from Mr. Patel's testimony of the position of these two men that that second individual was preventing Mr. Flores from escaping the vehicle and thus escaping any of the possible firings from the weapon. I think there's also possibly some argument of foreseeability as well as the fact that he was aware Mr. Llamas had the weapon. He was aware they had been in the car. They had been driving around for several minutes.
Now, we don't have any direct testimony that he was aware of the weapon.
That is correct, Your Honor.
The judge says, oh, it's a small car and it's a rifle, so he must have seen it.
I think it's possibly true of when Mr. Llamas got into the vehicle. However, as soon as Mr. Navarro pulls into the motel behind Mr. Flores and he pulls a rifle, it's certainly not a small gun, out of the car to get out, I think there's at least some implication that he would have seen that.
So what? So what? That they get to the parking lot at the roadway inn and the shooter gets out with the weapon.
Well, there's, I believe...
And the defendant here gets out of the car. At that point, what did he do to aid and abet if he didn't know anything was going down at that point?
Well, I think that's also a very key point, Your Honor. I do believe that he did know something was going down, but even aside from that, the fact that he didn't leave, the fact that he did actually stay seems to add his approbation to the act, which I believe under case law can be sufficient to find someone guilty under an aiding and abetting theory.
You're saying that it's aiding and abetting if you don't stop and if you don't run away yourself?
Well, I think there's, I believe, a particular case on point, and if I remember correctly, if I may have a moment, Your Honor.
Well, what I'm getting at is there a duty to stop a defendant from committing the crime, and the failure to do that is aiding and abetting? I didn't think that was the law.
I believe you're correct, but my argument in response to that, Your Honor, would be that taken with other factors, taken with foreseeability, taken with the fact of the history between these two men, taken with the fact Mr. Navarro had threatened Mr. Flores' life, taken with the fact in the prior pattern of enforcing behavior, Mr. Llamas traveling with Mr. Navarro to the burrito shack to make sure everything went well, because I believe Ms. Camarena testified that Mr. Navarro was kind of afraid of Mr. Flores and didn't trust him. So he had Mr. Llamas come with him and a couple other men come with him to make sure that nothing went wrong. This pattern of enforcement, this pattern of knowledge, and this pattern of threats by Mr. Navarro, all made in Mr. Llamas's presence and with his active participation up to that. I think those combined with the fact he did not run away, he did not immediately call the police, and he did, at least under direct testimony of Mr. Patel, assist in driving the car away, I think those form a nexus within which he can be convicted of aiding and abetting.
Why, when there is that pretty extensive pattern of enforcement and pattern of threats, and Mr. Navarro's trying to get his money and all this that went all along over a several-week period, why would we assume that at this very last occasion somehow this defendant knew that this was going to be different? This wasn't just going to be a continued harassment or trying to get the money, that somehow this was going to be a different deal. What's in the record about that?
I believe the record would actually reflect the fact that for several months prior to this, I think through July and August, the pattern of enforcement was more like, we want the money, we're going to get the money. And I do believe there was an escalation up to this point. I believe there was an escalation from, I would like my money, I need you to get me my money, to I'm going to get my money, I want my money. And I think there's a a more and more strident request for it at each subsequent meeting. And the thing I would ask that you to recall is that Mr. Flores is not present in Emporia during most of this time. He is hiding from Mr. Navarro, something which Mr. Navarro knew and had asked certain friends to keep a lookout for him. So I think you have a pattern of isolated incidences which escalate in intensity up to this point. I think there's, obviously...
All of that really tells me that we have a reasonable inference that defendant aided and abetted an aggravated assault to collect a debt. I mean, the fact that he knew that Navarro wanted to get his money and that he was using more and more aggressive techniques doesn't lead to the logical inference that he was going to shoot him, because you don't collect a debt from a dead person. And the reasonable inference was he brought the rifle along to continue the collection efforts. But what needs to be proved here is that there was an aiding and abetting of a discharge of a firearm at an occupied vehicle, correct?
That is correct, Your Honor. I would agree with that statement.
So all that you said, why does that lead to a reasonable inference that he would know that that was what Navarro was going to do?
I think we have some evidence in the record, and I believe this is correct, that Mr. Navarro had gone from saying, I'm going to get my money one way or another, to I'm going to kill him. And I believe he had made that explicit statement, and it had been, heard by Joe Myers. It had been heard by...
When did he make that statement?
I believe that statement was made as short as 2 to 3 weeks prior to the actual shooting incident. But again, with the issue of Mr. Flores being in and out of Emporia, I think it was kind of one of those things where he showed up, it flared up. Mr. Navarro got angry at that point. He made statements, and then it died down. And while he is still looking for him and would take other people out to go look for him, it was a consistent effort. But I think Mr. Flores' presence in Emporia certainly did aggravate the frustration and the anger and ultimately the homicidal rage that he felt in order to collect the money, because he had been duped and cheated.
You refresh my recollection. This prior pattern of trying to enforce collection of the debt, did any of those involve the use of this .22 rifle?
As far as I'm aware, Your Honor, no. There were no other instances where there was a weapon present. I think what Mr. Navarro was relying on was sheer numbers. He brought friends with him to the burrito restaurant to, in the vernacular that is popular in Emporia, watch his back. He was afraid that Mr. Flores would try something, so he brought friends with him and had them stationed in a position where they could intervene if necessary, but were not necessarily intimately involved in the conversation that ultimately led to the extension of time to pay.
And does the record reflect the time in which, as the judge indicated, the defendant should have known that there was a .22 rifle in the small car until the actual shot was fired?
If I remember correctly, Your Honor, and it's a fairly voluminous record, so I'm doing best I can here, the statements were actually made by Mr. Llamas that he and Mr. Navarro followed. They went over to the Sunny Slope address, which is where Mr. Flores was supposed to have been in Emporia, and they drove around looking for him. And I believe the statement was that they drove around for several minutes, anywhere from 5 to 15. I believe there are a couple of different iterations of time. So anywhere from 3 minutes up to 15 minutes at the maximum, I think, assumption here, or the maximum statement, that they were driving around in this car looking for Mr. Llamas and finally found him and followed him to the motel. So there are several minutes during which we obviously don't have any record of what was said in the car, and we can't make those inferences. I think that would be unfair. But at the very least, we know as soon as Mr. Navarro gets out of the car and pulls the rifle out from wherever it is, he's either got to pull it out of the back seat where it's going to almost hit Mr. Llamas in the head because he's pulling it over the headrest, or it's between the seats. It's somewhere where it's very obvious as soon as he pulls it out to get out of the car. And I believe Mr. Llamas' testimony was that he got out of the car and ran. So if he could get out in the car and run away after he watches this happen, why couldn't he get out and run before when he sees the gun come out? Because he's already heard his friend talk about how he wants to kill this man.
And does the record indicate how long a span of time there was from the time the shooter got out of the car until he pulled the trigger?
I don't believe there's any specific mentions of time, Your Honor. I believe there's just a description of what happened. And as I recall that, he got out of the car. He had pointed the gun at Mr. Flores. There was some arguing back and forth. Mr. Flores attempted to grab the gun. And then at that point, Mr. Navarro opened fire. So I don't know that we have a precise estimate of time in that. I think it's probably one of those things that on paper sounds like a long time, but probably didn't happen in a blink of an eye, but certainly wouldn't take as long to happen as it would to write it.
Thank you.
Thank you.
Counsel, were you counsel at trial?
I was not, Your Honor.
Okay, I wondered if you have any information about why the victim witness, or excuse me, the accomplice witness instruction was as limited as it was?
To the exclusion of Ms. Camarena?
Yes, I believe that's the only argument your opponent's making is as to her.
Yes, Your Honor. My understanding is that based on the fact that Ms. Camarena was actually peripherally involved, based on her own testimony, her statement was that she gave Mr. Navarro the $2,000 and she didn't really know what he did with it. She assumed he bought the drugs because of what happened later. He came back without it. She didn't even know specific dates when he had left and come back. Mr. Navarro's phone was not working after he came back from California. He had run out of minutes. So anybody who wanted to talk to her was anyone who wanted to talk to him was using her phone, and she was simply a conduit through messages were passed. She was working 8 to 5 that summer. She wasn't really home when all of these men were hanging out at her house drinking beer. She would hear things second and third hand, where you've got Mr. Myers, who is actually acting as the enforcer at the burrito restaurant. He is actually passing information that is integral to getting Mr. Navarro to telling Mr. Navarro where Mr. Llamas is on the Sunny Slope address and getting him to be able to find him in order to either collect on the debt or complete the threat that he had made to kill him.
But she was the...
I'm sorry.
But she was the conduit of that information, that specific information. Why isn't that enough to make her an accomplice?
I think there's a question of foreseeability, Your Honor. And at the time where Mr. Myers called and informed her, hey, this is Joe, please tell Mike that Omar's in town and he's over on the Sunny Slope address. She says, okay, tells him, and then hands the phone over to Mike, and Mike starts making phone calls. She starts making dinner, and the next thing she knows, she goes looking for him to feed him dinner, and she goes out to the garage and notices the car is gone. So because she wasn't as intimately involved in all of these prior conversations and these prior meetings, I don't think it had the same impetus for her as it would for Joe Myers, because Joe heard it come out of Mike Navarro's mouth. He heard, I'm going to kill him, come out of Mike Navarro's mouth. She's hearing about it second and third hand. It's rumor at this point. She has no concrete reason to believe that anything like this shooting is actually going to really occur. Obviously, she goes, after she passes the message, she goes and makes dinner.
Who decides if somebody's an accomplice, the court or the jury? Or the prosecutor, I guess, in this situation.
Well, I will admit that we did give a grant of immunity to both Ms. Camarena, but even after the exclusion of Ms. Camarena from the specific accomplice witness, there are...
If she wasn't an accomplice, why did she need immunity?
She was not an accomplice to the crime of firing into an occupied vehicle, Your Honor. She would have been an accomplice to the purchase of the methamphetamine, perhaps because she provided the money. But there is when jury instructions are questioned, Your Honor, I believe it's the...
And the getaway.
And after the fact, correct.
Exactly.
Thank you.
I mean, that part resembles the gentleman who we're here about today.
I think there's still a differentiation there because of the amount of time we're talking about. But to answer your question, Your Honor, jury instructions, I believe, should be taken as a whole, and there is still the other cautionary instruction that the jury is to give the appropriate weight and credit to all of the testimony that they hear. So even if Ms. Camarena is not specifically identified as an accomplice witness, they are aware of her relationship with Mr. Navarro. They are aware of her relationship within the pattern of these events and would certainly be able to make their own decision as the fact finders in this case.
Assuming we would find error on that point, do you agree with the defendant's argument that we would apply a constitutional harmless error standard?
I'm trying to figure out what the constitutional issue is. It's not a Sixth Amendment confrontation issue because he had the opportunity to cross-examine Ms. Camarina and make whatever points he needed to make about her credibility and to impeach her if at all possible. So I don't believe that in this case it would be an appropriate standard to use because I don't see what the constitutional issue would be. And I will admit, I don't have as much legal experience as you do, but that would be my argument.
Very good. Do we have any further questions of counsel?
Yeah, we have two of the witnesses that testified, or at least we have the judge, when he's discussing the evidence, say two of the witnesses testified that they thought that was just talk when Navarro said he was going to kill, and there was no way that they believed it would actually happen. And so we have two of the witnesses testifying to the jury that they believed it was just talk. The judge goes on and say, well, we don't know what Llamas had in his head. But when they're hearing that from two of the people that were around when the statements were made, why would we think that the jury would ascribe belief to Mr. Llamas? If others present when the threat was made said it's just talk, no one thought he was going, or we didn't believe he would actually do it, why would Mr. Llamas think differently?
Well, there was nobody else in that car that night other than Mr. Llamas and Mr. Navarro. At some point, Mr. Llamas becomes aware of the fact that they're going to look for Mr. Flores because they find him. And at that point, they found him, and they do follow him. So there's at least a period of time where the two gentlemen are sitting in a car together following a man who Mr. Llamas knows.
Now, those are acts that are happening, that day.
That's correct,
I
yes,
heard
sir.
you argue that the fact that Mr. Navarro said, I'm going to kill Mr. Flores, was part of the mindset of why this defendant was aiding and abetting.
Yes,
And my question was, when the statement was made, at least two of the other people that were present testified that it was just talk, and they didn't believe that he really meant what he said about killing. And so how can we say, oh, well, with respect to Mr. Llamas, it's different. It has compelling consequences or compelling inferences for him when it didn't for the others. Do you understand what I'm trying to ask you?
I believe so, and please correct me if I don't answer your question. I'm going to do my best here. My understanding is, Your Honor, is that neither of those other individuals were actually present when the trigger was pulled. And if had Mr. Llamas not been present and someone else had been when the trigger was pulled, that prior knowledge is only a portion of, I think, what we have to look at. The portion of the facts and evidence that we have to take into account to create this reasonable foreseeability of harm. And if all we had were those prior statements of, I'm going to kill you, I'm going to get my money one way or another, there's a possibility that may not have been enough to convict him of an aiding and abetting. But you have these acts in furtherance. You have these assistances that he has given to Mr. Navarro that these other individuals have not. And I think that may be what takes Mr. Llamas's participation in this act from a mere association, from somebody who was hanging around with a guy who's just blowing off some steam because somebody didn't give him his money, to somebody who's actually truly criminally liable under an aiding and abetting theory for the death of this man. And I hope that answers your question, sir.
I inferred from some of your earlier comments that prior collection efforts, if you want to call them collection efforts, had involved not only the shooter in this case, but also some of his friends or associates.
I believe that is correct, yes, sir.
Was it ever more than just one other person?
I believe when it came to the Burrito Shack, they took not only Joe Myers, but I believe there was a third party there as well. I think that Mr. Navarro would go out and ride around looking in Emporia with kind of whoever was there. But again, there's those acts which are centralized on Mr. Navarro are dispersed throughout this group, except for the fact that you find Joe Llamas popping up much more frequently in all of these enforcement activities than you do any other one person.
What I was getting at is whether the record would indicate that this final act of collection was the first time that it had been just the shooter and one of his associates, or whether that had been done previously, or was it always more than two until this date? Does the record indicate?
I don't think the record is exactly clear on that. I think there may be some indication that I know there are statements that Mr. Navarro would go out looking for Mr. Flores, but with whoever was around, but I don't think it was ever explicitly stated if it was one person or more than one person. So I cannot answer that question. I'm sorry, sir.
All right, thank you. Any further questions of counsel? Thank you, counsel.
Thank you, sir.
We reserve 2 minutes for rebuttal.
I will not make a comment about the Tom Selleck mustache. Okay. Mr. Navarro said, I'm going to kill them. We have no evidence that Mr. Llamas actually heard that statement. That's actually by a different witness. And Justice Johnson is correct. No one actually believed him. So I want to make that clear. I also want to make a point about that we have no evidence that the .22 was ever brought in the car in prior instances. What the state seems to do is take a group of people and find the person who seems to be there more than the others. So 3 is more than 2, so we're going to choose number 3. The others all seem to be involved in this. You have Ruby, you have Ruby's brother, you have Michael involved, you have a lot of players involved in this. None of this rises to aiding and abetting. I think that maybe we have a debt collection, as this court says. Knowledge is not enough to show aiding and abetting. And so I just wanted to make the point of not calling the police still doesn't get us to aiding and abetting. The specific intent of discharging a firearm, how would he know that this incident would be different from the others? The state hasn't been able to show that. The state says that there's an escalation here, but again, we're not privy to these conversations between Mr. Flores and Mr. Navarro. Regarding Ruby as an accomplice, she did more than just work 9 to 5 and make dinner. She supplied the money. She bought the ticket for Mr. Navarro to leave for Mexico. She let him use her cell phone. She would interpret for him. She was the one, when her brother Joey called and said, guess what? Mr. Flores is on Sunny Slope. She was the one who passes that message on to Mr. Navarro. And she's the one who the state says there's no foreseeability. She couldn't conceive that this has happened. Actually, her testimony says differently. Her testimony after she tells that message is, she thought something terrible was going to happen. What happened because he's gone after Joe had called. That's her direct statement. So we do have her with being aware. I think she, more than any of the other players here, would be more the aiding and abetting than Mr. Llamas.
Ms. Pickering, excuse me.
Go ahead.
The immunity that was granted to the girlfriend was in this case. It was for the murder, wasn't it?
Yes.
It wasn't for some drug crime.
No, right. That's all there was.
Opposing counsel was asked by one of my colleagues, what is the constitutional right that's at issue here that would require us to apply Chapman?
For issue
identify
2,
that right? Yes.
I was looking through that, and to answer your question, Justice Lukert, and it may be a right to for the caution of the testimony of a accomplice. I don't think it's clear. It may be the defendant's right to due process to have a fair trial, so that the jury can view her testimony with caution.
All right, thank you.
Thank you.
Any further questions of counsel? Thank you both for your arguments this morning. The court will take this matter under advisement.